Production. Honorable Omido, we will be engaging you on your application that you made for the position of a judge. Before we delve into the interview, please confirm your county and your ethnicity.
Thank you, Your Ladyship. My ethnicity is Kisii. County is Kisii County. The county is 045.
Thank you very much. Commissioner Macharia, who will start us off.
Okay, a few questions. You are at the level of a senior principal magistrate.
Yes, Commissioner.
Right. So the first question would be that why don't you take a shot at the next level of a CM, exercise those powers, and be able to demonstrate, your skills in that expanded jurisdiction before coming for the judge position?
Thank you, Commissioner Vice Chair, for that question. One thing I know about this commission is that it's an equal opportunity employer. And the commission looks at one's qualifications and one's satisfied. Of course, depending on who else has applied, once satisfied may proceed to nominate a candidate for the position of a judge of the High Court. I know under Section 30 of the Judicial Service Act and Article 166 of the Constitution of Kenya, the law provides for the qualifications that one needs to meet before applying for this position of a judge of the High Court of Kenya. My Lord, Your Ladyship and Commissioner, I believe I qualify. I have all the relevant qualifications that are required for this particular position, and that perhaps informed the decision for the Commission to shortlist me. I will further go to state that under Article 166.5 of the Constitution, it is particularized as to the requirements in terms of experience that one requires for this particular position. And under that provision, it talks about, the total number of years served, or the total number of years one has been an advocate. You will notice from my CV that I worked for an insurance company after admission, and I practiced in 2 law firms before I joined the bench. Such that if you put together the period that I served in private practice, in the corporate field, and in the judiciary as a magistrate, the total number of years perhaps may even be more than some of my colleagues who are chief magistrates. The other thing I want to say is that I think this is also a personal journey. It is a personal journey, and each of us has their own, their own targets, their own manner in which they want to grow in each other's, in respect of one's own career path. And my view is that having served for the total number of years of 22, I am ready to serve as a judge of the High Court. I will talk about my journey because it serves part of the experience, my journey in the judiciary. I joined the judiciary in the year 2008, and what mainly informed my decision to join the judiciary as a magistrate, as a resident magistrate, is the calling to serve. You will remember that in the year 2008, we were fresh from having the post-election violence in this country, and the political players blamed the judiciary for that, as being part of that problem. You'll remember well that immediately after the election, some of the players indicated that they were not ready to file the matters before the courts because they did not trust the courts. So that informed, because I wanted to make a difference, it informed my decision to join the judiciary at that time. So therefore, after discussing the matter with my employer at the time, an advocate in Mombasa, I applied and came into the judiciary.
All right. Now, because I have a limited time, now you just said that in as much as you are at the lower level of SPM, that one of the, of course, consideration by the JC is also dependent on the others who have applied. And you see, which, you know, you've rightly pointed out, the others who have applied who are senior than you. Let's stay with the JOs because that's where you are. Many chief magistrates. But then you'd have to demonstrate to us that you have something bigger than them in terms of contribution to jurisprudence or something you've done that is monumental so that we can leave them and they pick you. So could you very briefly, don't answer in too many words, what is it that you've done that makes you better than them?
If I understand you well, you are looking for the specifics.
Absolutely, specifics. I want you to, because there are many other CMs who have also applied.
Thank you.
Forget about the ones from the outside, yes. So that when we leave them, even the public can say, we left them for you. I mean, we picked you and not them because it's something that you have that is really bigger than them in terms of contribution or impact.
Thank you for that question, Commissioner. Let me start by going back to my first station, which was Karatina Law Court. At the time that I served in Karatina, we were 2 magistrates, myself and my head of station, and there was the Mungiki problem at that time, which was quite a big problem. We had very many of those matters coming to court. My colleague's parent happened to come not too far away from that area, and the parent was threatened, which then meant that she stopped handling those matters, and I started handling all of them, the ones that were at Karatina Law Court. Well, I handled those matters, and what my experience was is that as a judicial officer, you must be courageous. I say so because I was actually threatened. I was threatened, you remember at the time, SIM cards were not registered. I received many text messages. In a particular case, we had 21 suspects, and there was an objection to them being granted bond. I received many text messages daring me, I may say, not to grant them bond, so that they come then for my head. I made a report to the judicial administration and to the police, but I proceeded to handle the matters because I thought, because if I don't handle them, my colleague has already been threatened indirectly, then who will? I proceeded to handle the matters, and I will say that those who are threatening me even came to my house at night, threw stones onto the roof, and sent me a message on the morning of the ruling that we know your house, we are the ones who threw stones. I went ahead, I rendered my ruling, and in my view, the main reason as to why I did not grant them bond at the time was for their own security. Yes, so that is one thing that I've grown with, courage in the judiciary. That is one. I can go to another specific. When I worked in Nakuru Law Courts as a deputy registrar, I participated in an election petition as a deputy registrar, in which I was directed by the High Court to do scrutiny of the ballots of the votes. I did the scrutiny, but looking around the law, there was no, the law did not provide the manner in which we are supposed to report. The manner in which the report is supposed to be made. The report from the deputy registrar to the judge. But I formulated my own, I formulated my own report, which I thought was within the parameters of the law and within my work. And commissioners, I'll say this, that the report that I prepared, because it was in the form of a table with notes, was used by other judicial officers, and even is the basis upon which we have now a report. The table upon which...
yes, somebody else, I'm sure, will engage you more on that.
Yes.
So my final question, you know, one of the challenges that, of course, any judge or judicial officer will face is the issues of, you know, we want an accountable and, you know, a judge who has integrity and one who understands the issues of conflict of interest. Now, I want you to tell us, because I'm seeing at one time you were at Nairobi City Court.
Yes.
Which you'll agree is one of those notorious courts. Previously. A lot of underhand issues, underhand dealings, particularly even including the issues of rates, those rates cases.
Yes.
I'm speaking that, you know, as a practitioner who understands that. Now, demonstrate to us how you dealt with that, with those issues, because, you know, there even used to be allegations of, you know, collusion between sometimes the judicial officers and, you know, those managing the resources at the county government level. I'm sure you heard about that, right?
I heard about that.
You heard about that,
yes.
and it's a known thing. Again, I'm speaking that from my knowledge and experience. Then, as you answer that question, tell me the issues of conflict of interest, how a judge is supposed to handle it, or a judicial officer for that matter, because these are recurrent issues. You know, you'll find a matter coming before you, either the party, you know, is closely associated with you, is known in circumstances that would render the decision making not one that can be perceived to be one that is accountable. Even us, we face the same thing here at the commission, where, for instance, like the first candidate for me or somebody who works in my firm, I know I would be not conflicted, but to avoid perception, you say, I will not participate in it. So under those circumstances, what is your take on it? How is it supposed to be handled if you became a judge? How have you handled it on your part?
Thank you for that question. I will start with the City Court, and I would absolutely agree with you, Commissioner, that a lot goes on at the City Court. Yes, I handled matters under the Rating Act, and I realized that there was a problem, first with the legislation. And the biggest problem we had with the legislation and the Rating Act is that it provides, I do not know whether that is the subsisting position today, that the Act provides that when you're serving summons, you do not have to serve the person, the owner of the property, that you can actually fix or fix those summons at a prominent place on the property, which I find quite absurd. Well, that was the law at the time, and that was what I was dealing with. But what I did was to go back to, I don't recall the decision, but there is a decision of the Court of Appeal, Justice Ringera, which says personal service is the best service. So any time I received an affidavit of service indicating that we served by affixing on the gate or on a tree that is prominently on the property, I would simply state that to me that is not satisfactory service, because you need to start from the bottom. You need to start from the bottom. And that did not work very well. In fact, they started avoiding my court. Yes, avoiding my court, and I even got, I think, 1 or 2 applications for recusal on the basis that I was, I was evading the law. That was, I remember that was the word that was used. I was evading the law by making a decision directing that personal service be made or be attempted first. Of course, I handled those applications for recusals, and my view was that those were matters for appeal, not recusal. That was my decision. Then there is the problem, the bigger problem of the bylaws. Then we had the bylaws, the Nairobi City bylaws. We had the councillors.
Okay, you can go to the issue of the conflict of interest so that we wind up, because my colleagues will.
Thank you. On the issue of conflict of interest, my take is that if anything arises that would result in my impartiality being skewed in any way, first of all, I have a duty as a judicial officer or as a judge to disclose to the parties, and if I am of the opinion or I have the feeling that I will not be objective in handling this matter in light of that type of conflict, the best thing to do is to recuse myself and write those reasons as the reasons for my recusal. I do not have to wait for parties to bring an application for recusal. Thank you.
Thank you very much, Honorable Chair. Honorable Omido, just 2 questions from me, very simple for you, bearing in mind that you're a judicial officer. In a criminal matter, when does the suit abate?
My lady, in a criminal matter, the suit abates upon the death of an accused person.
Right. What about in a civil matter?
In a civil matter, similarly, the suit abates upon the death of an accused person, upon the death of a party, of a plaintiff in this particular case, but there is a window period of 1 year within which to keep that suit alive or revive it by substituting.
All right, by filing an application for substitution.
Yes, my lady.
And finally, from me, what is the place of circumstantial evidence in a criminal trial?
Thank you for that question, my lady. Circumstantial evidence is evidence that can actually be put together. Different pieces of evidence can be put together to ascertain the existence of a fact. So circumstantial evidence can actually be used to prove a fact, my lady.
Can it be used to convict?
It can be used to convict if it is so clear that it establishes the existence of that fact.
What are the words that are used? What are the words that are used? You can convict using circumstantial evidence if...
my lady, I'm not certain.
The totality of the evidence irresistibly points to the guilt of the accused person.
Thank you, my lady.
Thank you. Thank you, Chair.